Your pond is a drainage hazard. You have 14 days to bring it into compliance, or the association will take remedial action at your expense." She said it the way someone says a thing they have rehearsed, standing at the edge of my gravel drive in a blazer that had no business being on a working property, a clipboard pressed against her chest like a shield. Her name was Renata Voss, and she was the enforcement chair of the Millhaven Shores Homeowners Association. She had driven out in a white SUV so clean it looked like it had been unwrapped that morning. I stood there in my work boots listening, and I did not say a word until she had finished. What she did not know, what she had no way of knowing, because she had never looked at the actual record, was that the 12-acre pond behind me sat on land I owned outright, not adjacent land, not disputed land. My land, deeded to my family before the Millhaven Shores development, existed as anything more than a surveyor's sketch on a planning table. The deed was in a fireproof box in my study, and it had been there for decades, and it said what it said. Drop a comment and tell me where you're from, and if something like this has ever happened to you, I want to hear it. I took the notice from her hand, folded it once along the middle, and put it in my jacket pocket. Then I thanked her for coming. She looked at me for a moment, that slight pause people have when they expect resistance and don't find it, and then she walked back to her SUV and left a thin trail of dust on the way out. I watched the dust settle. Then I went inside, put the kettle on, and called my attorney. That is where this story begins, more or less. But to understand what happened next, and why it ended the way it did, you have to go back a great deal further than that morning. My grandfather, Elias Croft, came to this part of the county in 1941 with very little except a surveyor's certificate, a willingness to work in weather that discouraged other men, and a specific idea about what land was worth. Not in dollars, in time. He used to say that a piece of ground was only as good as the number of mornings you had walked it before breakfast, and by that measure, he made this land very good indeed. He acquired the original 340 acres through a small inheritance, a land grant auction, and a handshake deal with a neighbor who was moving west and wanted to leave the property in hands he trusted. The deed was recorded at the county clerk's office in the fall of 1941, and it described the parcel in the precise language of the era: meets and bounds, compass bearings, distances in chains and links, with the pond specifically called out as a natural water feature, lying wholly within the described boundary. He built the farmhouse first, then the barn, then the long cedar post fence that ran along the eastern boundary and still stands in most of its original form today. He cut those posts himself from trees on the property and set them in concrete he mixed by hand. I know this because he told me, and because I have reset several of them over the years and seen the original pour, still solid, still plumb, the way things are built when the builder expects them to outlast him. My father, Raymond Croft, inherited the land in 1978 and ran it as a working cattle operation for 20 years. He sold about 60 acres on the northern boundary in the early 1980s to fund a barn expansion, but he kept the pond parcel intact. He understood, as my grandfather had understood, that water on dry summer land is not a feature. It is the land's spine. You do not sell the spine. I am the third generation to hold this deed, and I have held it now for going on 19 years. My name is Thomas Croft. I'm a civil engineer by training, which means I have a professional habit of reading documents carefully and a deep distrust of anything described in vague language. When I took over the property, I spent the first 3 months doing what most people do not bother to do. I read every recorded instrument associated with the land. The original deed, the 1978 probate transfer, the 1983 partial sale, the utility easements, the county road right-of-way, all of it spread across my kitchen table in chronological order, cross-referenced against the current plat map from the county assessor's office. It took the better part of a week. The pond was unencumbered, completely. It sat within the original boundary, had never been subject to any easement or covenant, and had no recorded claim against it from any adjacent property or association. I filed the documents in labeled folders in a banker's box and went on with my life. The mallards that nested in the reeds along the south bank each spring did not know the pond was mine, but they behaved accordingly. Millhaven Shores was developed in the middle of the decade following my father's death. A developer named Carver Group purchased the northern 60 acres my father had sold in 1983, along with several adjacent parcels, and built a planned residential community of roughly 140 homes. The HOA was established in the development's covenants and governed the properties within the platted subdivision boundary. That boundary was clearly drawn on the recorded plat. My land was not inside it. My pond was not inside it. The boundary ran along the old fence line my grandfather had built, and it stopped there, as boundaries tend to do when they are properly described. For several years, there was no friction. A few residents walked their dogs along the county road. One family asked permission to fish the pond, and I said yes. The HOA managed its own affairs. I managed mine. Then Renata Voss was elected enforcement chair. A neighbor of mine, a retired school teacher named Gerald Hatch, who had lived on the county road for 40 years, told me that the board had shifted in tone after the last election, a new energy in the meetings, a desire to expand the scope of what the association considered its responsibility. Gerald had attended a few of those meetings out of curiosity and reported back with the dry amusement of a man who recognized institutional overreach on sight. "They've got a map up on the wall," he told me one afternoon, leaning on my fence post with a coffee thermos in his hand. "And the map shows your pond as a community amenity. I thought you should know." I thanked him and went inside and looked at my deed again. The deed said what it had always said. I put it back in the box. The first certified letter arrived about 3 weeks after Gerald's visit. It was from Millhaven Shores, HOA, over Renata Voss's signature, and it informed me that the pond, which they called the retention feature adjacent to the Millhaven Shores community boundary, was in violation of the association's stormwater management guidelines. The letter cited Section 4.7, subsection C, of the HOA's own covenants, which addressed stormwater retention requirements for properties within the development. It did not explain how a property outside the platted boundary could be subject to those covenants. It simply asserted that it was. The proposed fine was $350, with an additional $50 per day of continued non-compliance. I read the letter twice. Then I read Section 4.7, subsection C, which I had obtained from the county recorder's office the previous year out of professional curiosity. The subsection read, in relevant part, "All retention features located within the boundaries of the Millhaven Shores planned unit development shall be maintained in accordance with the following standards, within the boundaries." I underlined that phrase with a pencil. Then I made a copy of the letter, put the original in a labeled folder, and called my attorney. Paul Deering had handled property matters in this county for 30 years and had a manner so unhurried it could make you forget he was charging by the hour. He listened to the whole thing without interrupting. When I finished, he said, "Did they include a legal basis for jurisdiction?" I told him they had cited Section 4.7, subsection C. He asked me to read him the full operative language. I did. There was a pause. "Well," he said, "that's interesting." That was the most animated I had heard him in a while. He told me not to respond yet. He wanted to pull the recorded plat, the HOA's declaration of covenants, and the county assessor's boundary map before we said anything in writing. I told him I already had copies of most of those documents. He said he would be at my kitchen table on Thursday morning. He arrived with a leather briefcase and a thermos of his own coffee, which I took as a sign he expected to be there a while. We spread the documents across the table in the order he wanted. Plat map first, then the HOA declaration, then my deed, then the assessor's parcel boundary overlay. He worked through them in silence, making occasional notes in a small spiral notebook with a mechanical pencil. I refilled his coffee twice. Outside, the pond sat in the gray morning light, its surface moving in a slow wind, the reeds along the south bank bending and straightening in a rhythm that had nothing to do with any of this. After about an hour, Paul set his pencil down. "Your property line," he said, tracing it with one finger without touching the paper, "runs here. The HOA's platted boundary runs here. There is no overlap. There is no shared jurisdiction. There is no recorded covenant that binds your parcel to their declaration. He tapped the table once gently. They have no legal basis for this claim, none that I can find in any recorded instrument. I told him I had reached the same conclusion. He nodded as if this did not surprise him. The question, he said, is what they do next. We did not have to wait long. The second certified letter arrived 11 days later. It informed me that the association had determined the pond represented an ongoing drainage hazard, that the association had authority under its stormwater management protocols to take remedial action if a property owner failed to comply, and that if I did not bring the pond into compliance within 7 days, the association would exercise its remedial authority to address the drainage condition. The letter was signed by Renata Voss and countersigned by the board president, a man named Dale Wicker, whose name I recognized from the community newsletter Gerald occasionally left on my fence post. I called Paul. He read the letter and was quiet for longer than usual. "Thomas," he said, "I want you to document the current condition of that pond. Photographs, measurements, water level. Do it today." I told him I would. "And if anyone sets foot on your property without your permission," he said, "call me before you call anyone else." I photographed the pond that afternoon from 6 positions along its perimeter and noted the water level against a cedar post I had marked with a painted gauge line years earlier. The pond was full. It had been full all spring. There was no drainage hazard visible to any reasonable observer, and I had a civil engineer's eye for drainage conditions. I logged the photographs with timestamps and put them in a new folder labeled with the date. 3 days later, I woke before dawn to a sound I could not immediately place, a low mechanical hum from the direction of the pond, steady and purposeful in the pre-light quiet. I pulled on my boots and walked out. They had brought a pump, a commercial-grade submersible unit, the kind used in construction dewatering, mounted on a trailer parked just inside my property line on the county road easement strip, or what Renata Voss apparently believed was a neutral access corridor. 2 men in work vests were managing the discharge hose, which ran through the fence gap and into the drainage ditch along the road. The pump was already running. The water level in the pond had dropped, visibly, from where I stood. I did not raise my voice. I want to be clear about that. I walked to within speaking distance of the nearer man, who looked up with an expression that was not quite guilt and not quite confidence. And I said, "You are on my property. Please stop the pump and wait here." He looked at the other man. The other man looked toward the road as if calculating something. I took out my phone and called Paul Deering. It was 5:47 in the morning. Paul answered on the second ring. By the time the sun was fully up, the pump had been stopped, but the damage was already significant. The pond had lost, by my estimate and by the gauge post, roughly 4 feet of water depth across its 12-acre surface. By the following morning, the number was closer to 8. They had run the pump through the night. 12 acres of water drained to a shallow, muddy remnant, the reeds along the south bank standing exposed and pale, the mallard nests along the near shore sitting dry and abandoned. The pond my grandfather had called the spine of the land was nearly empty, and Renata Voss had no idea what she had just done. Paul Deering arrived at my kitchen table the following morning with his leather briefcase and a look I had not seen on him before. Not alarm exactly, but a focused attention that told me he had been thinking about this since before dawn. He set 3 documents on the table in a row. The first was a certified copy of my deed, pulled directly from the county recorder's office. The second was the recorded plat of Millhaven Shores, with the boundary lines traced in red pen. The third was a document I did not immediately recognize. A 2-page instrument on county recorder's paper, older than the rest, with a heading that read, in the typeface of another era, Declaration of Water Rights and Riparian Appurtenances, Croft Family Trust, recorded in the office of the county clerk, volume 14, page 312. I looked at it for a moment. Then I looked at Paul. "I found it when I was pulling the chain of title," he said, in the tone a man might use to report finding a $20 bill in an old coat. "Your grandfather recorded it in 1954 through an attorney named Whitmore who practiced out of the county seat for most of that decade. The language is thorough, more thorough than it needed to be for the time, which suggests Whitmore knew what he was doing." Paul sat down and opened his spiral notebook. Read it carefully, Thomas. All of it. Then I want to tell you what I think it means. I read it. It took the better part of 20 minutes because the language was precise in the way that mid-century legal drafting was precise. No word wasted, no ambiguity tolerated, every term defined within the body of the instrument itself. The declaration established in formal recorded language that the natural pond lying wholly within the metes and bounds description of the Croft family parcel was subject to a recorded claim of water rights under the doctrine of prior appropriation as it applied in this state. Those rights included the right to maintain the pond at its natural fill level, the right to control all inflow and outflow affecting the pond's water volume, and, this was the sentence I read twice, the right to seek legal remedy against any party whose actions reduced the pond's water volume below its natural seasonal baseline without the express written consent of the property owner of record. I set the document down. Outside, through the kitchen window, I could see the pond in the distance, its surface dull and low, the mud ring around its perimeter still pale in the morning light. Prior appropriation, I said. Prior appropriation, Paul confirmed. Your grandfather filed this 13 years after the original deed. My guess is that he had a dispute with someone upstream. There was a farm operation to the north in that period that diverted surface water. Whatever prompted it, he went to Whitmore, and Whitmore did the job properly. The rights were recorded, indexed against the parcel, and have been part of the chain of title ever since. He paused. The Carver Group's title search would have found this when they developed Millhaven Shores. Any competent title search would have found it, which means the HOA's declaration of covenants was written with constructive knowledge that these water rights existed. Constructive knowledge is a legal term meaning you are considered to know what the public record says, whether or not you have actually read it. The HOA had been formed with constructive knowledge of my grandfather's 1954 water rights declaration. Every letter Renata Voss had signed, every fine she had proposed, every assertion of remedial authority, all of it had been made in the shadow of a recorded instrument that directly contradicted the legal basis of her claims. Paul let me sit with that before he continued. The pump operation is the critical event, he said. If they had simply sent letters, we would be arguing jurisdiction, a dry procedural dispute. But they ran a commercial dewatering pump on your pond without consent and without any legal authority. They reduced the water volume below its natural baseline. That is a direct violation of a recorded water right. He tapped the 1954 declaration. This document is the mechanism. What they did with that pump is the trigger. I asked him what the remedy looked like. He turned his pencil end over end on the table. We file in district court, trespass, interference with water rights, and a claim for restoration costs. The state water rights statute provides for treble damages in cases of willful interference with a recorded prior appropriation right. The pump operation, combined with the certified letters asserting authority they don't have, makes a strong case for willfulness. He looked at me steadily. I also want to file a complaint with the county recorder's office regarding the HOA's recorded claim of jurisdiction over your parcel. That claim is a cloud on your title. We need it removed from the record. I asked how long it would take. The court filing I can have ready within the week. He closed his notebook. Thomas, the pump crew. Did they have paperwork? I told him that one of the men had shown me a work order after the pump was stopped. It was on a contractor's letterhead, naming Millhaven Shores HOA as the client. The scope of work was described as emergency stormwater remediation, retention feature adjacent to community boundary. I had photographed the work order with my phone. The timestamp on that photograph was 6:14 in the morning. Paul looked at me for a long moment. You photographed the work order? I did. He nodded slowly, in the manner of a man who has just been handed something he did not expect but is very glad to have. That is the chain of custody. Work order, client named, scope described, your property identified. Combined with your time-stamped photographs of the pump and water levels and the gauge post measurements, that is a complete evidentiary record. He began packing his briefcase. I'll have the complaint drafted by Thursday. Write me a chronological summary of everything that happened from the moment you first heard the pump. Treat it like an engineering report. That was a thing I knew how to do. I spent the following 2 days writing the summary exactly as Paul had suggested, the way I would have written a site incident report. Time, observation, action, documentation. No interpretation, no emotion, only the sequence of events as I had experienced and recorded them. I included the timestamps on the photographs, the gauge post readings before and after, the work order photograph, the names of the 2 crew members, and the time of my call to Paul. I printed it, signed it, and made 3 copies. I also called Gerald Hatch. Gerald had seen the pump trailer on the county road that morning and had driven past it twice. He had taken photographs from his truck window, the trailer, the discharge hose running through the fence gap, the contractor's logo on the pump unit. He had not known what to make of it at the time, but he had kept the photographs because, as he put it, something about it didn't sit right. The metadata on his images showed timestamps from before dawn. They were, in the dry language of evidence, corroborating documentation from an independent witness. I added Gerald's photographs to the file and sent everything to Paul. What I found, as the days passed and the file grew, was that Renata Voss had been extraordinarily thorough in documenting her own actions. Every letter she had sent was on official HOA letterhead, signed and dated, with the relevant covenant section cited. The work order she had authorized was on a contractor's record. Dale Wicker had countersigned the second certified letter. The board had voted according to minutes Gerald had obtained from the community center's public notice board to authorize remedial action regarding the drainage feature at a meeting 3 weeks before the pump arrived. The minutes named the motion, the vote count, and the members who had voted in favor. They had put everything in writing, every assertion of authority they did not have, every vote to act on that authority, every instruction to the contractor who had carried out the pump operation, all of it in the record, signed, dated, and indexed. I did not respond to any of it. I logged it, filed it, and let Paul do the work. The filing arrived at the district court on a Thursday morning, as Paul had promised. The complaint named Millhaven Shores, HOA, Renata Voss as enforcement chair, and Dale Wicker as board president. It alleged trespass and interference with recorded water rights under Volume 14, page 312 of the county records, and sought restoration costs, treble damages under the State Water Rights Interference Statute, and a declaratory judgment that the HOA had no jurisdiction over any portion of the Croft family parcel. Paul filed it with the complete evidentiary record attached as exhibits. My deed, the 1954 Water Rights Declaration, the plat map showing the boundary, the HOA's certified letters, the work order photograph, my time-stamped photographs of the pump and water levels, and Gerald Hatch's corroborating images. The process server delivered the complaint to Renata Voss on a Friday afternoon. Gerald told me about it the following day. I was not there for any of it. I was at the pond, measuring the water level against the gauge post and noting, with a civil engineer's precision, the rate at which it was recovering. The spring rains had been steady, and the inflow from the natural drainage basin was consistent. The pond was rising, slowly, and not yet to its natural baseline, but rising. The reeds along the south bank were standing straight again. There were 2 mallards on the water near the north end, moving in the unhurried way that mallards move when nothing is threatening them. I noted the water level in my log, took a photograph, and walked back to the house. The document that had changed everything was 13 pages long, recorded in a county ledger in 1954, and it had been sitting in the public record for 70 years. My grandfather had put it there. He had paid Whitmore to draft it, and had driven to the county seat himself to file it, and then he had gone back to his farm and cut fence posts and set them in concrete and gone on with his life. It had simply been there, in the chain of title, waiting. That is the thing about a properly recorded instrument. It does not need you to remember it. It does not need you to defend it or argue for it in a room full of people. It sits in the record, indexed and retrievable, and it says what it says to everyone equally, whether they have read it or not. Renata Voss had constructive knowledge of my grandfather's water rights declaration from the day the Millhaven Shores covenants were recorded. She had simply never looked. The hearing was scheduled for a Tuesday morning in late spring in the district court at the county seat, a low brick building with a parking lot that smelled of warm asphalt and the particular institutional quiet of a place where consequential things happen without ceremony. I arrived early and sat in the hallway outside the courtroom with my banker's box on the chair beside me and a cup of coffee from the gas station 2 blocks away, which was not good coffee but was hot. Paul arrived 7 minutes after me, in his good suit, carrying his leather briefcase and a newer accordion file I had not seen before. He sat down and opened the accordion file on his knee without preamble. "There is something I want to show you before we go in," he said. He removed a single page, a printout from a county recorder's database index, and laid it across his knee so I could read it. 2 lines near the middle of the page were highlighted in yellow. The first read, Volume 14, page 312, Declaration of Water Rights and Riparian Appurtenances, Croft Family Trust, recorded 1954. The second directly below it read, Volume 14, page 312, Cross-Reference, Appurtenant to Parcel described in Volume 8, page 44, Croft Deed, 1941. Rights run with the land in perpetuity. Rights that run with the land. Not rights that could be separated from the parcel by a subsequent sale, or extinguished by a developer's platting of an adjacent subdivision, or overridden by a homeowners association's declaration of covenants. Rights appurtenant to this land since 1954, running forward through every transfer, every probate, every partial sale, into my hands and beyond. The HOA's attorney will argue that the Water Rights Declaration is an old instrument of limited scope, Paul said, his voice level. He will argue that the association's stormwater management protocols represent a more current regulatory framework that supersedes a mid-century private filing. That is the argument he has telegraphed in his pre-hearing brief. Paul tapped the highlighted lines. But the statute is clear. A prior appropriation water right recorded in the public record is a property right. It is not a permit. It is not a guideline. It is a deeded property right, and it runs with the land, and it cannot be superseded by a private association's internal governance document, not in this state. He paused. The association's attorney cited the general provision of the Water Rights Code. He did not cite the remedies section. He produced a second document, a printed page from the state code, with a passage underlined in yellow, Section 47, subsection 12. Any person who willfully interferes with a recorded prior appropriation water right, including by diversion, extraction, or reduction of water volume below the natural seasonal baseline without the express written consent of the right holder, shall be liable for actual damages, treble damages, and the reasonable costs of restoration. The work order is the willfulness. They hired a contractor. They authorized the scope of work in writing. They named your pond as the target. That is a deliberate act against a recorded property right. I picked up my coffee and held it for a moment without drinking it. The hallway was filling with the ordinary traffic of a courthouse morning. Clerks with folders, a young attorney talking quietly into his phone, a couple seated near the far wall with the stillness of people waiting for something they do not want to arrive. Outside the tall windows at the end of the hall, the sky was the pale, washed blue of a spring morning after rain, and the parking lot trees were in their first full leaf. I thought about my grandfather driving to this county seat in 1954 with Whitmore's drafted declaration in his hand, filing a document he may have considered routine, a protection against a water dispute with a neighbor upstream, a piece of professional caution, a thing worth doing properly. He had not known that 70 years later his grandson would be sitting in this hallway with a banker's box and a gas station coffee, waiting for a hearing that would turn entirely on the language Whitmore had drafted and he had signed. He had simply done it correctly, and correctly had been enough. One more thing, Paul said. He produced a single printed email. This came yesterday afternoon from the HOA's attorney, a settlement offer. He let me read it. The offer proposed that I withdraw the court complaint in exchange for the HOA's agreement to cease further enforcement actions against my property. No acknowledgement of wrongdoing, no restoration costs, no damages, a mutual release and a quiet exit. I read it twice. Then I handed it back to Paul. No, I said. He nodded once and put the email back in the accordion file. That was my recommendation as well. We went in. The courtroom was small and wood-paneled, the kind of room where the gravity is in the proportions rather than the decoration. The judge was a woman named Hargrove, who had been on the district bench for 14 years, and who had, according to Paul, a particular impatience with procedural claims not grounded in the actual record. Renata Voss sat at the opposing table in a blazer that was the same category of garment as the one she had worn on my gravel drive, though a different color. Dale Wicker sat beside her. Their attorney, a younger man named Forsyth, had a tablet propped in front of him and a manner suggesting he had prepared thoroughly for a different case than the one he was about to argue. Paul presented the record in the order he had assembled it. The 1941 deed. The 1954 Water Rights Declaration read into the record in full, including the operative language about prior appropriation, natural fill level, and the right to seek remedy for unauthorized reduction of water volume. The recorded plat of Millhaven Shores, with the boundary lines established and the absence of any overlap with the Croft parcel demonstrated on the county assessor's overlay. The HOA's certified letters, the board minutes authorizing remedial action, the work order, my time-stamped photographs of the pump and water levels, Gerald Hatch's corroborating images with their metadata timestamps, the chronological incident summary written in the manner of an engineering report. Forsyth's argument, when he made it, was the one Paul had anticipated. He cited the HOA's stormwater management protocols. He argued that the pond's proximity to the Millhaven Shores boundary created a shared drainage interest. He invoked the association's authority under its own covenants. Judge Hargrove let him finish. Then she looked at the documents on her bench for a moment, in the silence of someone who has already read the record and is deciding how much time to spend on a question whose answer she considers settled. "Counsel," she said, "the Water Rights Declaration recorded at Volume 14, page 312 is a prior appropriation right appurtenant to the Croft parcel. It predates your client's covenants by more than 50 years. It is indexed against the parcel in the public record. Your client's declaration of covenants does not and cannot supersede a recorded property right. The association's covenants govern properties within the platted boundary of the Millhaven Shores development. The Croft parcel is not within that boundary. This is not a close question." She turned to the documents on her bench and made a note. The court finds that the Millhaven Shores Homeowners Association had no legal jurisdiction over the Croft parcel or the pond lying within it. The court further finds that the pump operation of the date specified in the complaint constituted willful interference with a recorded prior appropriation water right under Section 47, subsection 12 of the State Water Rights Code. She set her pen down. The court awards actual damages in the amount of the restoration costs as documented, treble damages as provided by statute, and reasonable attorney's fees. A declaratory judgment will issue confirming the Croft parcel's exemption from Millhaven Shores HOA jurisdiction. The HOA's recorded claim of authority over the retention feature described in the complaint is vacated from the county record. She looked at Forsyth. The association's enforcement actions against this property are enjoined permanently. That was the whole of it. No drama, no raised voices, no theatrical revelation. Just the record, read by a judge who had read the record, arriving at the conclusion the record required. Renata Voss did not look at me when it was over. She gathered her papers and her clipboard and walked out of that small wood-paneled room, and I did not watch her go, because there was nothing instructive in watching her go. Dale Wicker followed. Forsyth packed his tablet and left without speaking to anyone. Paul shook my hand in the hallway briefly and told me the judgment would be entered within the week and that he would handle the filing to vacate the cloud on the title. I thanked him. He said it had been, in his considered professional opinion, one of the cleaner cases he had worked in 30 years, and that the credit belonged to my grandfather's attorney, who had done his job correctly in 1954. I drove home through the county roads, the windows down, the warm spring air moving through the cab of the truck, the fields along the road in the particular green of a season that has had enough rain. I turned onto my gravel drive and parked at the house and sat for a moment before getting out. Then I walked down to the pond. The water was nearly back to its natural baseline. The spring rains had been generous, and the drainage basin that fed the pond had done its quiet work over the weeks since the pump had run. The gauge post showed the level within 2 inches of where it had stood before Renata Voss's contractor arrived in the dark. The reeds along the south bank were full and upright, the way they had always been in late spring, bending in the same slow wind they had bent in for as long as this land had been in my family's hands. There were 4 mallards on the water near the north end, moving without urgency, their reflections trailing behind them in the still surface. The cedar fence posts along the eastern boundary stood as they had always stood, my grandfather's work, solid and plumb in their original pour, holding the line of a boundary that had never moved. I stood at the edge of the pond for a long time, in the quiet that a piece of ground earns when it has been walked enough mornings. The water held the sky. The reeds held their color. The land was what it had always been. Here is what I have come to believe, after all of it. When an institution with apparent authority makes a claim against you, the first question is not whether to fight it. The first question is whether the claim has a legal foundation. And the answer to that question is not in the institution's letters, or its covenants, or the map it hangs on its community center wall. The answer is in the record. The public record, indexed and retrievable, available to anyone who takes the time to look. My grandfather put the answer there in 1954 and asked nothing of it except that it be filed correctly. It was. And when it was needed, 70 years later, it was exactly where he had left it. Know your documents before they are challenged. Verify the legal foundation of any claim made against your property. The record is the only instrument that holds its value across every season, every transfer, every generation. Everything else is just paper that hasn't been tested yet. If you have ever dealt with a boundary dispute, an HOA overreach, or a claim against land you know you own, I would like to hear about it in the comments. And if you want to follow the next case, because there is always a next case, consider subscribing. The record, as they say, does not close.